Hello friends, welcome to our class on IPR. Intellectual property right is a very important issue for all business and service units. Today we are fortunate enough to get a very eminent personality in the areas of IPR. He does not really require any introduction, but I would just like to say that Dr. Sushil Kumar Mitra, he was the former Deputy Controller of Patents and Designs, Government of India. He was also a scientific officer, Central Drugs Laboratory, and worked more than 40 years in the IPR. I had a very close relationship with him for a long period and learned several things on IPR. He is kind enough and agreed to deliver his lecture on three important areas of IPR, that is trademark, copyrights and patents. And I am sure all of you will be greatly benefited. Thank you very much.
Thanks, Mr. Chakrabarty, for kind words and giving the introduction about me before the viewers. Thank you. Hello, viewer. Today I will just discuss a very good intellectual property which is called the queen of all intellectual property rights, that is patent. Patent system in India and its development after joining TRIPS agreement, a part of WTO, is very important not for the big industries but also for the micro, small and medium enterprise as well. Why? Because the most of the micro, small and medium enterprise are creating job for the weaker section of the society, and also their contribution in the economy, 42% contribution in Indian economy, and their interest for innovation, for creation should be properly protected through the limb of patent. I want to explain further that before TRIPS agreement, we are very well known about four laws, that is the patent laws, design laws, trademark laws and copyright laws. But how the three laws are interacting with each other, that is very important. If I just remember a pressure cooker, all the spares of the pressure cooker marketed by Hawkins or Prestige, that is protected by a patent, that is technology. The beautiful shape and configuration and color combination which creates the aesthetic beauty of the product, no functional thing is there, that is protected by design. The name Hawkins or Prestige pressure cooker, that name is protected by trademark, and the manual of the pressure cooker, inside the pressure cooker kept in a box, that is protected under copyright. So whenever you are thinking for a business, for a product, so we must think of copyright, trademark, design along with the patent, because ultimately that technology plays the big role to create value additions and brand. So technology can be protected through a patent. Now, one very important thing, what is the role of patent system? Patent system is a system of encouragement. Someone is saying it is a system of recognition. Someone is saying it is a system of reward. But I must say it is a system of dissemination of knowledge. Why? Because whenever your product will be coming in the market, then other innovators are going to improve your product by a process of innovation. And that process of innovation is your creation and your product of mind, so that should be protected through patent because it is a technological advancement. It gives the value addition on your product so that the end user can have the better benefit over the prior product. So it is provided a reward, exclusive right. The right is given for 20 years from the date of filing. That is, the valid patent lasts for 20 years, subject to renew every year. 20 years from date of filing. And when you can make the profit, when you are putting the product in the market through your protected technology, or you can assign your right, license your right to the other company and getting profit through a process of royalty. But always keep in mind that it will transfer to the public domain after 20 years, and then all the persons of your similar competitors or similar field of business that can use the technology without falling into any infringement. But one very important thing, I look the MSME's interest on patent in different way. Big industries are looking for innovation, research and development, but it is not possible for micro, small and medium enterprise to invest money in research and development for the development of their product. Who are developing product? Big house. And MSME sectors are making the product through their technology which has been protected under patent. So my advice is that whenever you are thinking for a product or a business, always you go search in our patent database. Patent information is very important. We have 98% technology of today is open for utilization without falling into any infringement because it is a territorial right. Indian patent is only valid in India. Lot of technology in the world, in Japan, in USA, in Canada, in Australia, which has not been patented in India, only patented in their own country or their choice. Some countries are there, only they have protected their right in those countries. So those are free technology coming before you for utilizations. I am giving certain information. This is very useful. Punch card, very common punch card, that is published in patent document in 1889. But when it has come into a publication, that is 1914, after 25 years. So if you don't search patent database, that means your information 25 years down the line, the technology which has been published in patent literature, but normal publication in literature is coming in 1914 after 25 years. Then only the public can come to know, yes, punch card technology was there. So you will be backdated. Similarly, television. Television discovered in 1923, and when it has come into a public domain, 1928, after 5 years. Then 5 years you cannot get the information about the television technology, but already it is in patented technology and published in patent literature. Jet engine, 1936, that is after 10 years it has come into a published document. That means whenever you are getting published document in literature, that has come much after the publication of the patent literature. That means if you don't go for patent literature search, then you will be backdated, and also you can get the legal status of the patent, whether the patent is valid patent or not. If the patent is not granted but published, that is free technology for you. If the patent corresponding technology is not patented in India, it is free for you because it is a territorial right. So my advice, whenever you are thinking for any product, before launching a product, before going to research on the product, you must go for patent search. Only 5,000 to 10,000 rupees charge is there. You can go by search by an expert. and they will give you the information about your product. You can produce the product without falling infringement, and I am giving you the assurance that without putting any money, skill and time into research and development, you can develop the product with the help of the other technological information available in your patent information system. So that is the most important part for you, because MSME sector has very limited fund. So patent information systems we have developed because of to give information to our MSME sector for making the product without falling into any infringement. So at the point of time, we have given a lot of leverage to the pharmaceutical industries by a process patent, not the product patent. Because many companies can produce the product by different process and reverse engineering was allowed. But what happens nowadays? Now we have started the product patent regime from 2005. So nobody can produce the product without getting license from the product patent holder. Otherwise it will be an infringement. So nowadays your innovation should get the priority whenever you are getting patent on your innovations or technology. And if it is not possible for you, then you go on search on patent database for getting free technology, which is not coming a threat before you for taking the information without paying royalty to the patent holder. So this is the most important thing. For today's lot of things are available. From a desktop you can have a lot of information through different databases available in the world. But TRIPS agreement, when we have joined, we have given certain limitations. Limitations means that the product patent should be available in pharmaceuticals, compulsory licensing system, product patent and process patent, benefit of the public for the product patent and the process patent. But must keep in mind that your patent only will give on the invention. And we have two definitions of invention in our act. One is the simple definition is saying new product process having inventive state, that is non-obviousness and having industrial applications. But new invention, which is a basic invention, that is new molecule, new theory, new product, new process, which has not been published in any part of the world. But I am telling that our 98% patent granted from the world on the improvement, that of the basic technology, not the original technology. And the basic technology, the company who has produced, they are fencing their product by a creation of different child patents so that nobody can touch their blockbuster molecule or blockbuster technology. So all the things may not be patentable in India because we have the provision of Section 3. Section 3 prevents some of the inventions which are not patentable subject matter in India. You can take the opportunity of those inventions which are falling under non-patentable invention in India. So lot of things are there. You may not be aware about the thing. You can contact our team members. I will tell the name and details of that. They will help you. They will guide you. They will support you so that you can protect your business and do the business and the protected market so that nobody can challenge whenever you put the product in the market. I am coming into a very vast area. When you go to file the patent applications, copyright and trademark, you can publish and then register. But in case of patent, first you have to file the application, then you have to go for publication or use. Prior publication, prior use will be considered as an anticipation for your invention, and the novelty will be destroyed. And if novelty be destroyed, then you cannot obtain patent. Your own publication, your own use may damage your new innovations. So before any kind of communication, before any kind of publication, before any kind of activities, you must file patent application. If not complete, you can file the provisional application. Then within 12 months, you can file the complete specification to protect your technology. Now, the jurisdiction. We have 4 patent offices in India. Anyone office, you can file the application online mode, or if you file the physical mode, then you have to file the application in the appropriate office in your jurisdiction. 4 offices are different states are divided into the 4 offices, and our Kolkata office covers the eastern part of India and the northeast, western part Bombay, southern part Chennai, and northern part in Delhi. So the specification is very important. How to disclose your invention? You must disclose your invention in such a way so that your trade secret of the invention will not be disclosed. Trade secret you can protect under confidential agreement through contract act. So drafting is very important. You may not be skilled in the drafting of the specifications. For the patent attorneys are there. And in my life I have seen, when I was in the position of controller in my office, that a very good invention is turned to a very bad patent because of bad drafting. And a very small invention has turned to a very strong patent because of good drafting. So drafting and disclosure is very important, so that nobody can copy your technology without your help, as well as you can protect your invention within the scope of your invention's product, so that nobody can infringe your product also. That is very important. You always keep in mind, initially you may spend 5,000, 10,000 rupees for drafting, but that will save $1 billion and nobody can copy without your help. And you can get good monopoly on your innovations. So procedure is very simple. After filing the application, it will be published, statutory publications, and thereafter, based on your request for examination, it will be referred to the examiner for examination, and controller communicate that first examination report to you. And within 12 months, 6 plus 3, 9 months, you have to give reply. If it is satisfied, then your patent will be granted, or the controller will offer hearing before taking any adverse decision on your applications. And based on the satisfaction of the controller will grant the patent. Whenever the patent will be granted, you will be the owner of your innovations, and you can claim your right from the date of publications when your application is disclosed to the public through Patent Office Journal. So this is the very important part, and not only in India. If you have a good business opportunity in other countries, you can protect through our patent cooperation treaty PCT system. And for the natural person, 90% rebate provisions are there. And Indian Patent Office now has become international cert and international preliminary examination authority. So with a very minimum amount of prescribed government fees and 90% rebate, you can protect your innovation in the countries other than India also, if you have the business opportunity in those countries also. It is not that you have to cover all the 160 countries of the world to do the business. You can select hardly 5 to 10 countries where you can export the product also. Then in that case, that patent in those countries are very essential. Otherwise, everyone can copy your technology and product wherever that will reach those countries. So this is also an opportunity to obtain patent in the countries other than India also. So I can give you just information. In the patent law, there is a provision for patent attorney. We are producing patent attorney every year, conducting examination and viva voce examination, and that person is responsible to draft the specification, to face the controllers, and to pursue your matter so that you can obtain patent. So patent attorney provisions are created by law to help our innovators, our scientists, so that they can obtain good monopoly of right for their own invention. And without law degree, any bachelor's degree in science can obtain the registration as a patent attorney and can practice before the controller and can help the innovator for protecting their innovations. So with this thing, just I want to conclude here that patent is a queen of IPR, and for that it is also very essential to do the business in the protected market like trademark and copyright. So last of all, I can say that if you have any questions, any queries, you can contact our team members, Dr. Tini Borun Chattopadhyay, TCN Global and Economic Advisory, as known as LLP. So in those, the person who is responsible to help your sectors so that you can get the opportunity to do the business with your IPR. Thank you.